They said the empire was built on gold, and now the headlines say the stories unfold. Flashing lights, courtroom rows, silence loud, and the pressure grows. From Harlem streets to the Forbes list, now he's sitting where the storm hits. Cameras on, but who's legit? Truth and lies in the same script. Diddy defense team got 8 on the move. Agnafilo, Jarago, Shapiro, Steele, Donaldson, Westmoreland, Estavo and Driscoll. The feds got him on 5 charges. They say he on that RICO. Media says he is guilty out the gate. 8 male jurors and 4 women hold his fate. No cameras allowed in the court. Content creators screaming more, more, more. Diamonds heavy, but the weight's not cash. Every step watched through the media flash. Friends turn foes and the past don't pass. When receipts get pulled and they come in stacks. Official transcripts will show the full story. Full statements, but the details may be gold. They wanna put me on trial, put my name on file. Want me to hang it up, but that ain't my style. Say I'm back on road, no hand on Bible. We got this game in a chokehold. Yeah, I'm so cold. My whole career they tried to test me and I aced it. When you want something done, you gotta go and get it. Hate to put you on blast, but it's not up for debate. When the odds stacked against me, victims' names not being used to keep from getting approached by the accused. Kanye showing up in white, saying Diddy fight, fight. What's legacy when it's on the line? Is the name you built still gonna shine? Or does silence scream like a warning sign while the world debates guilt or crime? Every empire's got a tale untold. Every mogul's got nights cold. But behind closed doors, who holds control? Truth is a mirror and it never folds. Spotlight shadows can't outrun fate. Every crown's heavy when it's tied to the state. From the charts to the court, it's a razor blade. Walking the edge that the headlines made. Did the feds charge Diddy for his crimes, or just for some freak off good times? Baby oil galore, but the feds say there is much more. Everyone is innocent until proven guilty. This will be left to the 12 on the jury committee. Is this a RICO, or just a man being major sicko? Was he really the king or just a fling? Did Diddy do what they say? Will NYC jail be where he will stay? Did he bop in the hotels on the top floors? Different bows in different area codes. Some would call them the defense saying evidence is a blur. Some witnesses concur. Will the bad boy for life be serving life, or will he get the win and be in the next jet to Berlin? Spotlight shadows can't outrun fate. Every crown's heavy when it's tied to the state. From the charts to the court, it's a razor blade. Walking the edge that the headlines made. The devil is in the details. While the world debates guilt or crime, is it RICO or freak off?
Diddy says he is love, love, love.
They said the empire was built on gold, and now the headlines say the stories unfold. Flashing lights, courtroom rows, silence loud, and the pressure grows. From Harlem streets to the Forbes list, now he's sitting where the storm hits. Cameras on, but who's legit? Truth and lies in the same script. Diddy defense team got 8 on the move. Agnafilo, Jarago, Shapiro, Steele, Donaldson, Westmoreland, Estavo and Driscoll. The feds got him on 5 charges. They say he on that RICO. Media says he is guilty out the gate. 8 male jurors and 4 women hold his fate. No cameras allowed in the court. Content creators screaming more, more, more. Diamonds heavy, but
Hey folks, it's me. I'm back. I'm back. I'm back. I'm back. I have the transcript from this morning's hearing. I have the current transcript, the full details of the courtroom. I was thinking about doing it for my members. I was thinking about doing it for my members because I hadn't done a members only live yet. So I was thinking about doing it for them and then push it out to the people. What do y'all think? What do you guys think? What do you guys think? I have the whole transcript. Let me see. Let me put my little trusty thing up right here so you guys can see that I actually got it. Let me show y'all. I actually got it. Here it is right here. Here it is right here. You see, I got the transcript. It's 168 pages. Mm-mm-mm. Sidebar. Let's see. Get all the way up here. Okay, here we go. You said for everyone because you're broke? You don't have $2 for a membership? I mean, I'm very like slow and fun, but $2, I got $2. And then you probably one of them that won't even hit the like button. You probably don't even hit the like button. I guarantee you don't even hit the like button, Ashley. And hitting the like button is free. That's a freebie, hitting the like button. You probably don't even share. You probably never shared my live, have you? Probably never shared my live. You probably never shared my live, never hit the like button, never shared the live, but want me to give you something. Hmm. And that's free. Sharing and liking is free. It's free. It has nothing to do with no membership. It's free. But I don't do that. I have to beg for that. I have to beg for hitting the like button and sharing. Oh, my stomach is growling. My stomach is growling. It's like, help me. I need to eat. Help me. Help me. Help me. Let me see. Hold on a second. I gotta make a phone call, y'all. Hold on. Hey, Miss Betty. All right, y'all ready? I had to make a phone call. I'm not going to read all of it tonight. I'm going to read as much as I can, and then I will stop. We don't even have the numbers in here. Maybe I just do it tomorrow. We don't even have the numbers. We only have 37 people. You're not even sharing it. You're not even sharing it. Rosie, you up? Did I not get the notification? Is it not going out, y'all? It's not it. You're not getting a notification. It's not it. What's not it? Attorney mom. What's not it? What's not it? Oh, you got a notification? Okay. I was trying to figure out why the numbers are not here. It's nobody. Oh, nobody's live. I've been with you from the beginning. I love your commentary. I used to be a member of my job, so I would love to become a member again. Soon will be. No, I'm good, Cynthia. I was just trying to get these folks to at least hit the like button, share the channel, something. And I can't even get numbers. But then people will want stuff from me, and then they're not even doing something. It's a two-way street. Y'all gotta hit the like button and share. You was correcting the grammatical error. It's not it. What are you talking about? Because I said Anthony mom and I said, oh, attorney mom. That's what you're talking about? You didn't get your notification, Jackie? Okay. I don't know what's going on. What's going on? Did he get 4 years? Yeah, he got 4 years. He got 4 years. 4 years and 2 months. Okay, so we're at 33 likes. Okay, so you guys are almost matching the likes. Thank you guys for hitting the like button. But share it, okay? Share this live because I think I'm the first one to have these transcripts. Others don't have it yet. So you guys get to hear exactly what happened in the courtroom. Where's my boy Travis? Where's he at? Travis, you're in the chat. Travis, you're in the chat. I don't want to start reading and then people not here. All right, y'all ready? And here we go. It says, Miss Slavic got up and she says, good morning, Your Honor. Christy Slavic, Madison Smizer, Emily Johnson, Mitzi Steiner, Meredith Foster for the United States. We are joined at council table by paralegal specialist Shannon Becker and Chanel Foster, as well as Special Agent Sean Quinn of HSI and Task Force Officer Phil Askiwiski, also of HSI. Then the court says, good morning. Mr. Agnifilio says, good morning, Your Honor. We have Mark Agnifilo, Tenny Garrigus, Xavier Donaldson, Nicole Westmoreland, Brian Steele. We have Chris Johnson. We have Jason Driscoll. We have Alexandria Shapiro. We have Anna Estavio, and we'll have Representative Mr. Sean Cone. We are all represent Mr. Sean Cone. And he says, "Good morning." And then then says, "Good morning to you, Mr. Cone." And Mr. Cone says, "Good morning." First thing, do we have the signed consent preliminary order of forfeiture? I guess this is the money thing y'all was talking about. Ms. Slavic said, "Yes, Your Honor. We have 3 copies for each party and 1 for the court for your signature." And the court said, "Why don't you go ahead and hand it up?" And court deputy says, "Your Honor, I noted for the record that we also have a probation officer if she may give her appearance." Ms. Dennis says, and sorry, my God. Sorry, God. I don't know what's going on. Angelica, hold on, sorry, God. Angelica Dennis from from United States Probation. "Good morning," the judge says. "Let me give you an overview on how we're going to proceed." Guys, what's wrong with my throat here? Drama Comma, True Finder, please don't start today, okay? Please don't start because I'm gonna block you. I'm serious. Don't start this evening because I'm gonna block you. We ain't got no time for games, okay? First, I would like to go over the materials I have received and deal with the pre-sentencing report. Then I will review the sentencing guideline calculation. I will then hear from the government and from the defense and from Mr. Combs. Next, I will review the sentencing factors that I must consider in imposing a sentence that is significant but no greater than necessary to achieve the goal of sentencing. Finally, I will impose the sentence. In terms of the materials that I have received, there are a lot of them. I have received from Ms. Gurico the defense September 22nd sentencing memorandum, as well as the exhibits, including letters from family, friends, colleagues, fellow inmates at the MDC, and reports from the faculty facility at that facility, as well as the examination report from Mr. Combs' doctor. I have also received the September 24th letter from Mr. Steele and the exhibits and the second supplement from October 1st. I have also received the defense reply memorandum from October 2nd, and I have received the letter from Mr. Combs, Ian Melsnick, and Brian Steele last night. On October 2nd, as well as the video that the defense planned to play here in court. I have read all the materials and especially the letter. I greatly appreciate those. I read them very closely, so thank you for submitting those. I have also received the government's September 30th memorandum and the exhibits, including letters from Ms. Ventura and others. Again, the court greatly appreciate receiving those letters, all of which the court has closely reviewed. I have also reviewed the pre-sentencing report prepared on August 28th, 2025, and revised on September 18th. Does anyone have any further documents for the court, or did I miss anything? Ms. Slavic, Your Honor, just the consent forfeiture ordered, which you have. Okay. And the judge says, which I have received. Which I have now received. Thank you. Mr. Agnifilo, I believe That's everything, Judge. Thank you. Miss Moreland says, actually, Mark, sorry. Yes, Your Honor, we are going to submit Exhibit 85. We just received it this morning. It's a course evaluation for MDC that you have not yet seen. Not seen yet. And the court, can you hand that up? And Ms. Slavic says, the government has not received this exhibit. And the court said, have you a copy for Ms. Slavic? And Ms. Mullen said, it's on the way. The judge says, thank you very much. This will be made part of the record as well. Ms. Westmoreland says, thank you, Your Honor. And the judge says, Ms. Slavic, other than Mia, does the government have any plans for any victim to provide an oral statement during these proceedings? And Ms. Slavic says, Your Honor, and in fact, this morning the government learned that Mia no longer wishes to address the court here today. I'm comfortable representing to the court that is at least in part due to the letter submitted by defense on Wednesday, which can only be described as bullying. And I think in contravention to Your Honor's individual rule about civil liberty in proceedings. So Mia will not be making a statement here today. She has submitted a victim impact statement, a written statement, and we urge the court to consider Mia's experience in fashioning a sentence today. And the judge said, that's the letter that was attached to the government sentencing memorandum. And she says, that's right, Your Honor. Then the judge said, which I have reviewed. Thank you very much. Mr. Agnifilio says, I'm going to turn it over to Mr. Steele on this question, Judge. And then the judge says, I will say that the tone of the defense letter was inappropriate. So I agree with Ms. Slavic on that point. And Mr. Agnifilio says, I understand. Judge says, and that should not be done again. And he says, very good. And the judge says, Mr. Steele, does the defense plan for any individual other than Mr. Combs to make a statement during today's proceedings? Mr. Steele said, yes, sir. And the judge says, who? Steele says, 2 or 3 of Mr. Combs' children. They are in your courtroom, Your Honor. They will all come up with the court's permission to stand next to each other, but there will be 2 or 3 of them speaking. In addition to that, Dr. Reverend Gary Johnson, you have a letter from him, Your Honor, as well as, Your Honor, if you want to hear from Dr. Kruger, Dr. Kaplan, they are not in your courtroom, but they are in your courthouse in the overflow room. And if you have any question about their analysis, they are here to talk about Mr. Combs and their evaluation of him. Then the judge says, just so I understand, in addition to Mr. Combs' children, the second individual is Mr. Johnson. Is that right? And Mr. Steele says, correct. And the judge says, they will be speaking, and then the doctors, if we need to hear from them, they are in the courthouse. That's what you're telling me. And Mr. Steele said, there is one other person, Your Honor. He wrote you a letter about the reentry program, Giovanni. He was speaking as well with the court's permission. He will be speaking as well with the court's permission. And the judge said, Ms. Slavic. And Ms. Slavic said, Your Honor, I believe that all of these individuals that Mr. Steele have mentioned have submitted written letters, and I believe that several are featured on the video that the defense intend to play as well. As Your Honor knows, Rule 32 provides for a limited subset of individuals. Circuit has interpreted this narrowly. It's interpreted Rule 32 to apply to the parties, the defense and the defendant, and the government, as well as victims. And the court is as well within its right to circumscribe other individual, including character witnesses, from speaking on at sentencing. That is from the Second Circuit's case. The Dirigot case at 940 F3D 167 from 2019. Judge Furman has recently invoked this law and this precedent to limit defense witnesses speaking at sentencing. And I will just note, for Your Honor, that there is some level of irony in the defendant's objection to Mia speaking, one witness speaking for 5 minutes. It appears that the defense is trying to drown out the voice of victims in favor of character witnesses, and the court is well within the law to circumscribe that. And the judge says, but but you would agree, in the same way that I overruled the defense objection of Mia speaking here, I would be within my discretion to permit the individual identified as by Mr. Steele to speak, right? And Ms. Slavic said, yes, Your Honor. The court has every right to impose its discretion. It can permit these folks to speak. It doesn't have to. And I will note again that these individuals have all provided letters and some are featured on the video. And the judge said, understood. And the judge says, understood. And Mr. Steele, obviously, Mr. Combs' children will be permitted to speak. Is it Pastor Johnson? I don't want to be disrespectful. And Mr. Steele said, you are never disrespectful. Dr. Reverend Johnson. The judge says, Dr. Reverend Johnson is going to be brief statement. It's going to be a brief statement. And Mr. Steele says, correct. The judge said, that's fine. I'm going to think about the other individual that referenced to determine whether there is any need for the court to hear from those people, okay? And Mr. Steele says, of course. And the judge says, Mr. Agnifilo, have you read this pre-sentencing report and discussed it with Mr. Combs? Mr. Agnifilo says, I have, Your Honor. The judge says, Mr. Combs, have you read and discussed with Mr. Agnifilo the pre-sentence report? And Mr. Combs says, yes, I have, Your Honor. And the judge says, Mr. Agnifilo, is that correct? And Mr. Agnifilo said, it is correct. The judge says, there are a number of objections to the pre-sentencing report. So we will go through them first. A foundational objection raised by the defense in the extent to which the court may consider so-called acquitted conduct to determine the correct range under the sentencing guideline. In 2024, the guidelines were amended to provide that for purposes to determining the correct guideline range, relevant conduct does not include conduct for which the defendant was criminally charged and acquitted in a federal court, unless such conduct also establishes in a whole or in part the instant offense of conviction. From the guidelines section 1B1.3c, there is no guidance for from any court on proper application of the acquitted conduct provision. And the guideline is ambiguous, given that in most cases, including this one, injuries don't acquit defendants of conduct. They acquit them of charges. And we don't have a crystal ball to tell us what the jury in this case was thinking when they acquitted Mr. Combs of the RICO and sex trafficking charges. However, the application note to be the guidelines with reference to overlap conduct, suggesting that the real test is simple: to determine whether the conduct that underlines an acquitted charge also establishes in whole or in part the instant offense of conviction. That's what we are meant to determine. As to what establishes in whole or in part must mean in part means it's best understood as a relevancy test. Evidence is not relevant if it does not tend to prove or disprove an element of the offense. Nothing in the guidelines suggests that the commission intended for courts to ignore conduct relevant to establishing the offense in question. So, a more restrictive reading of this language is untenable. Of course, this will lead to some line drawing questions, which the commission recognized, stating that the court will be in the best position to determine whether such overlapping conduct establishes in a whole or in part the instant offense of conviction and therefore qualifies as relevant conduct. The court has done its best to do that. The court observed that even though the defense originally proposed a different definition at page 11 of their reply brief filed yesterday, they end up proposing pretty much exactly the approach that the court has adopted. Having said all this, it is important to understand how narrow and, in this case, insubsequential all of this is. The limitation on considering acquitted conduct only applies to determining the guideline range, not for any other purposes under the guidelines. And the guidelines themselves are only advisory. For every other purpose, the guidelines in 18 U.S.C. Section 3661 make clear that no limitation shall be placed on the information concerning the background, character, and conduct of a person convicted of an offense which a court of the United States may receive and consider for the purpose of imposing an appropriate sentence. For those purposes, the Supreme Court and the Second Circuit have made clear that acquitted conduct may be considered. For this, I cite United States versus Muir, United States versus Vaughn, and United States versus Watts. So even if the court is foreclosed from considering certain conduct in determining the correct guideline range, it considered all the facts applying to the preponderance of the evidence standard to impose a sentence sufficient but not greater than necessary to comply with the purpose set out in 18 U.S.C. 3553. With that, we move to the parties' specific objection to the pre-sentencing report, which will also address the parties' objection to various guidelines calculation. We will start first with the government's objection. The government first argues that the cross-reference in guidelines section 2G1.1 C1 should apply, and that the correct guideline range should be the criminal sexual abuse guideline, which is in section 2A3.1. The application of that guideline dramatically increased Mr. Combs' guideline range, imposing a six-fold increase in the minimum guideline sentence alone. The cross reference applied if the offense involved conduct described in 18 U.S.C. Section 2242. The conduct described in Section 2242 is engaging in or causing another person to engage in a sexual act with another person by threatening or placing the victim in fear other than by threatening or placing the victim in fear that any person will be subjected to death, serious bodily harm, or kidnapping. That tracks the language of the statute in Section 2242. Look into case interpreting that statute. There is little precedent on that kind of threat or fear of harm is required, binding or otherwise. The government cites to United States versus the engine a summary order in which the court did not directly address the issue because the defendant's sole argument was based on the wrong statute. It was also ruled in a Rule 11 case and didn't really get into what the standard is or should be. The Sand Treaty recommends a requirement that the defendant's action implicitly place the victim in fear of some bodily harm. The treatise adopted this view because, although the statute has an upheld against the vagueness challenge, allowing threats and harm to have unlimited reach would certainly raise a constitutional question. The text of Section 2242 suggests that a narrow reading on one that requires the imminent concrete threat of harm, such as bodily harm, makes more sense. But its terms, the statute applies to harm others than those for death, serious bodily injuries, or kidnapping. That borrows language from 18 U.S.C. Section 2241, which requires the threat of those things. Those are imminent concrete harms relating to physical violence or restraint. And Congress used the parallel language in Section 2242 suggests that it should apply to harms of the same kind, even if they are not as severe. Contrast that with the language in 18 U.S.C. Section 1591, which defines serious harm to include any harm, whether physical or non-physical, including things such as psychological, financial, and reputational harm, language absent from Section 2242. The court's adoption of a narrower reading is reinforced by the rule of lenity, which applies to guidelines under binding Second Circuit case law, United States versus Parkins. That brings the court to the evidence that Mr. Cohn caused Ms. Ventura and Jane to engage in sex act by threatening or placing them in fear of an imminent concrete harm, such as bodily harm. In this case, the government points to evidence of force, fraud, and coercion as supporting application of cross-reference. This conduct was the conduct underlying the acquitted sex trafficking charge, and it counts as acquitted conduct based on the court's analysis. As to whether the conduct also establishes it's in a whole or in part The offense of conviction, the government argues that evidence of coercion and the victim's resultant fear is relevant to establishing the defense intent that Ventura and Jane were being transported for the purpose of engaging act of prostitution with escort. That's from the government's brief at page 63. On page 63 and 64 of its brief, the government cites to two things fitting that category: the defendant's threat to release sex tape of Miss Ventura, including during a flight back to Canines, France, and his demand that she engage in freak-off, which in the case of Canaan's trip happened right after the flight. For Jane, they point to evidence of the defendant coercing Jane into engaging into a hotel night while he was arranging it by employing threats concerning her home. That's all from the government's brief again at page 63 to 64. There is no doubt that this evidence counts as coercion. What is not clear is whether it meets the technical definition under section 2242. To be very clear, as the court will later address, there was fear of bodily harm and other kinds of threat in this case. The court listened carefully to the witnesses during the 8 week of trial. Ms. Ventura and Jane testified credibly that there was psychological, emotional, and physical violence in connection with the freak-offs and hotel nights. But the technical question the court is dealing with, the intersection between the acquitted conduct provision and the 2A3.1 cross-reference, complicates things. The question is whether there is evidence that would establish in whole or in part the prostitution charges, that also proves by the preponderance of the evidence that the defendant caused Ventura and Jane to engage in sex acts by threatening or placing them in immediate fear of the kind addressed in 2242. The government hasn't made that case here. For that reason, in light of the dramatic impact of an application of the cross-reference, the constitutional question raised by Sands, the acquitted conduct guideline, and general principle of lenity, the court declines to apply the cross-reference. However, as I previously noted, the court considers all relevant conduct, including what might otherwise count as acquitted conduct under the guidelines. In determining the appropriate sentence under 3553A factors, so the court's resolution of this guideline issue would not affect the sentence ultimately imposed. Because the court does not apply the cross-reference in section 2A3.1, it also does not apply the enhancement for serious bodily injury in that guideline provision, although again it considers that evidence in fashioning the appropriate sentence here under 18 U.S.C. section 3553A. Next, the government objects to the lack of an adjustment for obstruction of justice. The court overrules the objection for the reasons set forth by the probation department in paragraph 79 through 80 of the PSR and on page 58 of the PSR. As to the incident relating to the bail application, considering Mr. Cohn's marking of pads as legal, this was troubling conduct. For purposes of the obstruction of justice enhancement, however, a full record was never made as to what happened actually or who was responsible for it. Mr. Cohn, his counsel, present or former, or both. If the government wanted to press for the record to be complete as to this issue, it could have, including after trial, but it did not. The first time the issue resurfaced was in the PSR. The court declines to apply the enhancement on the basis of the record it has. The government's objection is overruled. The government's objection for probation department not to applying the vulnerable victim enhancement under guideline provision 3A1.1 as to Ms. Ventura and Jane. The court overrules the objection. The application note to this provision has an express carved out that applies if the factor that makes the person vulnerable victim is incorporated into the offense guideline. It further points to an example where there is an age enhancement in the relevant guidelines saying that the victim enhancement could only be applied for reasons unrelated to age, indicating a broad conception of this language. The court agrees with probation in the PSR that the offense guideline here incorporates the factor that made Ventura and Jane vulnerable, as it includes an enhancement for fraud and coercion, with coercion focusing on the voluntariness of the victim, which is tied to the factor that the government points to as rendering Jane and Ventura unusually vulnerable. What made Combs' coercion effective was that the victims were vulnerable, and that was for lots of reasons, including prior sexual and violent experience and age. The court also observed that there is some questions as to whether Ms. Ventura and James would count as unusually vulnerable and particularly susceptible under the case law cited by the defense. However, the court need not reach that question. Once again, the court observed thought would reach the same ultimate sentence whether or not this enhancement as a technical matter applies or not. Next, we move to Mr. Combs' objection to the PSR. Mr. Combs objects to a number of paragraphs in the PSR, not based on their factual content, but the court's consideration of information that he deems related to the RICO and sex trafficking counts of which was acquitted. Those objections are overruled for the reason I laid out earlier. The court may consider acquitted conduct for any purpose other than determining guideline range. There is a small objection to the nomenclature, I don't know how to say that, in paragraph 70 that was resolved by the probation department, changing the language of that paragraph. But in any event, the nomenclature of Commercial Sex Act is irrelevant for this purpose of sentencing. Nevertheless, prostitution is a commercial sex act. Next, Mr. Combs objects to the characterization of Miss Ventura and Jane as victims. That objection is overruled. The evidence at trial and the material in the pre-sentencing report establishes by a preponderance of the evidence that Miss Ventura and Jane were victims. That is especially true given the definition of victim in the guidelines, which is a person transported for the purpose of engaging in commercial sex act, whether or not the person consent to the commercial sex act or prohibited conduct. Even after Supreme Court's decision in Kaiser versus Wilkie, the Second Circuit has held that the application note is entitled to Steinson deference. That's United States versus Rainford. Mr. Cohn also objects to the escort being classified as victim. The objection is overruled for the same reasons. The application note definition of victim is expansive, and the escorts were plainly transported for the purpose of engaging in a commercial sex act. That's established by, among other things, Government Exhibit 1402. There is no contradiction between the text and the application. Note in Steinson again applies. Evidence at trial supported at least 7 escort victims: Clayton Howard, Jules Theodore, Paul Arthur, Corbell Williams, Julian Sapp, Reggie, and Rico. I point to the PSR at paragraph 84, Government Exhibit 1402 and Government Exhibit 1406. Next, Mr. Combs objects to the coercion enhancement based on the jury's acquittal on the sex trafficking count. That objection is overruled. The court agrees with the probation department and the government that this enhancement applies. The enhancement applies where the offense involved fraud and coercion, with coercion being defined as any form of conduct that negate the voluntariness of the victim. United States versus Swearingen. The court note that coercion often involves an impending threat or some negative consequences that will affirmatively befall a person he or she does not succumb to the pressure that is being exerted, and it found coercion where the defendant substantially impaired the victim's ability to choose her own course of conduct. When something is voluntary in this context, that means that it is unconstrained by interference, not impelled by outside influence. That's from Black Law Dictionary. According to Merriam-Webster, it also means something that is proceeding from the will or from one's own choice or consent. That is very broad concept. The 2 instances cited by the government's concerning Combs' threat to release videos of freak-offs to Ventura and threats concerning James' home in connection with the hotel nights alone proves by the preponderance of the evidence that coercion was used under the definition provided in the guidelines, and these are squarely permissible to consider even if counted as acquitted conduct. The evidence cited here to support this, the trial transcript at page 701 through 703, at 3278 through 79, the Government Exhibit B315, Government Exhibit B619, Government Exhibit A104 through 68 at 1353, Government Exhibit A104 through 70 at 1380 through 83, and the Government Exhibit A10473 and 74. And obviously, if the acquitted conduct exception had any narrower sweep than what the court has concluded today, the credible evidence at trial and the fact detailed throughout the PSR unquestionably support application of this enhancement. Okay. Again, though the court would impose the same sentencing applying the 3553A factor, even if this enhancement did not, as a technical matter, apply. Mr. Combs objects to the application of the enhancement in guideline section 3B1.1 for an organizer or leader of a criminal activity that involves 5 or more participants or was otherwise extensive. The guideline provision defines participant as a person who is criminally responsible for the commission of the offense, but not need have been convicted. It does not define otherwise extensive exception to that in assessing whether an organization is otherwise extensive. All persons involved during its course of the entire offense are to be considered. Thus, a fraud that involves only three participants but uses an unknowing services of many outsiders could be considered extensive. In determining whether a scheme is otherwise extensive, the Second Circuit focused on primarily on the number of people involved. That from United States versus Carozella. Here Ventura and Jane qualified as participants. They were victims, and the application note in section 3B1.1 provide that victims can be participant only if they promote the sexual conduct with respect to another victim. The court overruled Mr. Combs' objection to counting the escort as victim. So, Ventura and Jane count as a participant because by the preponderance of the evidence, they promoted the sexual conduct with respect to them by finding the escort, texting them to set an appointment, and handing them money. That's among other things. From trial transcript at page 516, 17, 540, 41, 531, 4727, 4738 through 39, and 4744. The court finds by a preponderance of the evidence that the offense also involved Combs and at least three criminally of other responsible participants: Christina Corin, Garen James, and Bridget Collins, and that it used the services of numerous outsiders that were particular and necessary to this offense, including Fahim Muhammad and Combs' various assistants. Combs was plainly the organizer of the freak-offs and hotel nights. All of that staff and all of the staff that he was using were acting as his benefit, for his benefit and his direction. And it was his money that was used to pay the escorts. Even if some of this evidence overlapped with acquitted RICO conspiracy count, it plainly establishes in whole or in part the offenses of conviction as it goes to defendant's intent to transport of escorts, Jane and Ventura for sex, and proof that the act were in fact of prostitution. The enhancement applies and the objection is overruled. But the court again note that the guidelines are only advisory and that it would impose the same sentence regardless of whether the enhancements applied. Mr. Cohn objects to the characterization of Ms. Ventura as a victim and will object to the restitution of her. Mr. Cohn even objects to Ms. Ventura filing for any victim's impact statement pursuant to the Crime Victim Right Act. As a restitution, the objection is mute. Ms. Ventura is not seeking restitution. Oh, she's not seeking restitution, y'all. Okay, Mr. Combs' objection is otherwise overruled. Ms. Ventura was plainly a victim of Mr. Combs' conduct and plainly fits under CVRA definition of a victim. Mr. Cohn also appears to object to Ms. Ventura's statement not being included in the PSR pursuant to Rule 32. That provision states that the PSR must contain information that assesses any financial, social, psychological, and medical impact of any victim. The PSR does that thoroughly, and the final PSR summarized in quotes from her statement. Of course, the PSR does not contain all the information on the impact to the victim. If it were otherwise, no victim could ever make a statement on impact during sentencing because that oral statement would have, of course, not be contained in the PSR. For the same reasons, the court overruled Mr. Combs' similar objection as to Jane. Mr. Combs next object to the pre-sentencing report not giving him acceptance of responsibility credit under the guidelines, section 3E1.1. That provision is clearly inapplicable. The application note made clear that this reduction is inapplicable to defendant who denies the essential fact of guilty at trial and only later admits guilt and expressing remorse. Mr. Combs denied the essential fact of guilt, disclaiming his intent to hire escort for prostitution, saying he was paying for time, not sex. He has not admitted his guilt, and while he has expressed remorse for some things, he has not expressed remorse for the actual offense for transporting people for prostitution. In general, the narrative that he and his counsel put forward that this case involved nothing more than adult paying for time, not sex, is flatly inconsistent with both reality and an acceptable acceptance of responsibility. The defense point to the application note to guidelines stating that there are rare situations in which defendant may clearly demonstrate an acceptance of responsibility for his criminal conduct, even though he exercised his constitutional right to a trial, such as where a defendant goes to trial to assert and preserves issues that do not relate to the factual guilt. Here, however, Mr. Combs has challenged this factual guilt through throatably and even does so after trial. Cite here to United States versus Camara. We have held that the defendant who goes to trial to deny his factual guilt may not receive the adjustment for acceptance of responsibility. Mr. Combs next wants the court to apply the 0-point offender provision from the 2023 guidelines, but the rest of the 2024 guidelines. The Second Circuit has prohibited precisely that approach under its one-book rule. United States versus Ramirez. Mr. Combs would have to show that, as a whole, the 2023 guidelines would produce a lower sentence, but he doesn't even make that argument in this case. Further, even though the 2023 guidelines, the 0-point offender, the reduction would not be applicable because Mr. Combs received an enhancement under 3B1.1. For these reasons, the objection is overruled. Again, the court notes that the application of this reduction would not affect the final sentence imposed. Okay. Next, Mr. Combs objects to the imposition of the $5,000 assessment under Justice of Victim Trafficking Act because there was no victims. Here, the PSR and the offense of conviction established that the JVTA mandatory assessment unquestionably applies, so the objection is overruled. In the PSR, Mr. Combs has objected to forfeiture, but the parties have agreed to a consent order of forfeiture, and so this objection is now moot. At this time, I have consent preliminary orders of forfeitures as specified property. Mr. Combs, is this your signature on this last page of the order dated October 3rd? And Mr. Combs says, yes, sir. And the court said, "Did you review the order before you signed it?" And the defendant says, "Yes, Your Honor." And the judge says, "Did you discuss the order with your lawyer before you signed it?" And he said, "Yes, Your Honor." And Mr. Steele, did you review and discuss the order with Mr. Cohn before he signed it? And then Mr. Steele, "I personally did not, Your Honor." Mr. Steele said, "Nope, I didn't do it." And then Ms. Garrico said, "Your Honor, I went over this with Mr. Cohn." He says, the judge says, "Ms. Garrigos, did you review and discuss this order with Mr. Cohn before he signed it?" And then Ms. Garrigo says, "Yes, I did." And then the judge said, "The court will sign this order and it will be incorporated with the judgment in this case." Next, the defendant makes a request for a downward departure on the basis that the section 2G1.1 oversight the seriousness of the offense. That request is denied. The language is not in the 2G1.1 guideline, and the standard would not be met in this case in any event. To the extent not specifically addressed here, all the remaining objections by the government and the defense are overruled. Are there any objections that I have not addressed? Let's start with Ms. Slavic. Ms. Slavic says, "No, Your Honor." Mr. Agnafilo, and he says, "I just want to make one point to the record, Your Honor. I am not going to go objection by objection. Our live feed isn't working. You have mentioned that it is consequently, I think was the word to whether or not you view the acquitted conduct in the PSR, and I just want to put on record for Your Honor how consequential it is to have acquitted conduct in these certain factual allegation in the PSR for Mr. Cohn in the event that he gets an incarceratory sentence that's higher than what we requested. Because the way that it is worded, the acquitted conduct for which we have objected to have over and over again would lay him likely in a lower, and I may get to this later in the proceeding, but it is not inconsequential to all of Mr. Cohn in terms of what his incarceration at BOP would be like. Given the factual recitation, the offense conduct in the PSR, I really wanted to just make that point. And then it just said, "I understand the point, and I thank you for raising it." And it was prepared, not the right word to use. Oh, perhaps not the right word to use. So I make that clear in case it causes any issue down the line. The point was that for the purpose of sentencing analysis, and I went through this, the acquitted conduct provision solely applies to the determination of the correct guideline range and not those other purpose, not those other purpose, such as figuring out whether within the guidelines you might put a sentence, the purpose of departure, or the purpose of applying the 353A factor. That's what I meant to say. But if there is some other consequence and we can address that, I'm happy to. And Ms. Garrigo says, "We will address that if necessary later in the proceeding." But I just wanted to make sure that point clear now and make sure Your Honor understood it at this junction. And the judge says, "Understood." Hearing nothing else. And then Ms. Shapiro says, "I understand that Your Honor has ruled. I know the briefing is extensive, that we are preserving all the objection that we made. I don't know if this is the right point, but I wanted to make a few additional points to supplement the record with respect to Your Honor's record on acquitting conduct and a few other things, guidelines, other a few of these guidelines. I'm sorry, a few of these guidelines. Okay. Superior says, should I do that now? And then the judge said, you may proceed. And Shapiro said, thank you, Your Honor. I'm telling you, she's not playing. She's turning every rock over to make sure when they do the appeal, they will not say, oh, you didn't bring that up during the court. You didn't bring it up during this. You didn't bring it up. But she's taking care of all of it right now. Okay? I just want to be clear. This is a Shapiro token. I just want to be clear. And I think this is clear from the papers, because the briefs, both the opening and reply brief, were quite extensive. And then the judge says, I believe it was 380 pages in total. No, it's more than that. Then Shapiro says, I was talking about the briefs, Your Honor. I'll be very brief. I just want to be clear that the constitutional issue we raised, the Fifth and the Sixth Amendment issue, the right to jury trial, the double jeopardy, the due process, the right to finding beyond a reasonable doubt, the fairness concern, which I think are most, are set forth quite eloquently by, in particular, Justice Sotomayor in her McClinton opinion. But all of those constitutional and fairness concern, we believe, militate only in favor of our interpretation of the acquitted conduct guideline, but they also preclude the court in balancing the 3553A factor or choosing a point within the range, which such is chose to apply the guidelines and adopt the guideline sentence. That all of those militated heavily against any use of acquitted conduct. The jury had to find the elements of force, fraud, and coercion as defined in the jury's instructions. It's clear they rejected that. And that verdict and that finding should be honored. So that's our position. And I think, to be clear, for the same reason, the coercion enhancement, the victim enhancement, and the organizer leader enhancement should not be applied. And I want repeat the other points we made in our brief. But I just wanted to be clear on that, Your Honor. Okay? She's not playing, y'all. She wants to make it clear. And then it just says, all right, understood. And as noted in the Second Circuit, for example, in the mere case, indicate that the constitutional argument against acquitted conduct and its use at sentencing were squarely foreclosed by other precedents. Precedents, I'm sorry. I think that's almost a verbatim quote from Muir. But I understand the issue you raised, and it was extensively addressed in the papers, so you've made those arguments. And Shapiro says, thank you, Your Honor. I don't want the government saying we waive them on appeal. Should there be an appeal on the sentence? She's not playing, y'all. And the judge says, for these reasons and subject to the ruling made and the modifications that are addressed in what I've said, the court will adopt the pre-sentencing report and the factual finding therein. It will be made part of the record in this matter and placed under seal. If an appeal is taken, counsel to appeal may have access to seal report without further application to this court. Now goes to calculation of the guideline range. Mr. Cohn was convicted of 2 counts of transportation to engage in prostitution under 18 U.S.C. Section 2421A, each of which is punishable but not more than 10 years of imprisonment, 5 years to a lifetime of 5 years to a lifetime of supervision release and other monetary penalties. The pre-sentencing report reflects an offense of 27 and a criminal history category of 1. I have reviewed the PSR. I now calculate and find the defendant's offense is level 27 based on the analysis above that I've given the finding that I've made, including a factual finding in the pre-sentencing report. The court agrees with the probation department calculation of the offense level for each group as well as a number of groups. So the offense level is 27. The defendant's criminal history category is 1, as the defendant has 0 criminal history. The offense level of 27 and criminal history of 1 yields of advisory guideline range between 70 to 87 months of incarceration. Additionally, after determining the defendant's ability to pay, the court imposed a fine under the guidelines, Section 5E1-23C3, the offense level of 27, and the applicable fine between, listen to the fine, y'all. This is between, because everybody was saying he got to pay $500,000, $500,000. No, he says between $25,000 and $250,000. They said the range is between. So, guys, it's not $500,000 for the both. He gave 2 range. He didn't give her exactly what it is. Okay. This is what I was having an argument with somebody earlier. Ms. Slavic, are there any guideline arguments that I have not addressed or any other objection? No, Your Honor. Mr. Agnifilio. Agnifil. Oh gosh, I screw up the man's name every time. Agnifilio. Nothing from us, thank you. All right. I do not see a basis for departure here. After calculation of guideline potential, I must now calculate the relevant factors set out in the 18 U.S.C. Section 3553A to ensure to impose a sentence sufficient but not greater than the necessary to comply with the proposed set forth of subparagraph A and 2. At this point, does the government wish to make any final statement? All right, here we go. Any final statement? Okay, Ms. Slavic said, yes, Your Honor. Before we begin my statement, I just would note that given what I expected to be a lengthy and the breadth of counsel remarks, I asked the court to permit me to respond inappropriate to those remarks. Okay, y'all ready? Here we go. We're talking remark. I gotta give me some water. Hold on. All right, here we go. Where we at? All right, here she goes. She says, Your Honor, today is about accountability and justice. Accountability for the defendant who committed serious federal crime repeatedly over the course of 15 years. The justice for the public, including for the victim. Sorry, y'all. Hold on. Okay. Okay. 15 years and justice for the public, including the victims whose lives have been shattered by the defendant's act of abuse and exploitation. Uh, as the court note in its remarks just now, the law requires the court to consider all information about the defendant, all information about the conduct to impose an appropriate sentence. And when you step back to consider all the information available to the court, including all the evidence presented over 7 weeks, this past spring, it's clear. This isn't just a case of freak off or hotel nights. It's not just a case about sex. It's a case with real victims who have suffered real harm at the hands of the defendant, who, because of the defendant, have the question their own self worth and desire to live. It's about a man who did horrible things to other people to satisfy his own sexual gratification. He didn't need the money. His currency was control. He weaponized that currency to devastating effects on the victims. All of the 353A factors of the court is required to consider support a significant sentence of 135 months incarceration. And let me just say a word on the recommended sentence. The government very carefully considered that sentence to recommend here today. As this court knows, it's incredible hard to take into account all the specific features of a case and of the defendant. Among other things, the government considered a guideline range that we believe applies and compared defendants whose conduct most resembled the defendant's conduct in this case. And based on those considerations, we believe that the sentence of at least 135 months reflect the conduct appropriately inconsistent with other similarly situated excuse me, I'm belching, sorry. Defendant and fully respect the juror's verdict. Jury. And for your honor, just to directly respond to an accusation that was made by the defendant's reply brief yesterday, the government is not seeking 135 months, simply hoping that the court would split the baby to get to the 60 months recommended by the probation. That's not the case at all. Respectively, we believe that probation's recommendation of 60 months does not adequately account for the separate harm to Cassie and to Jane. We seek this sentence because we think it's the right sentence for the court to impose, given all the factors that I have mentioned. So I want to just lay out how I intend to structure my remarks this morning. First, I want to speak about the offense of conviction. The defendant has tried to turn this into a technical violation, just a minor consequence of a sex, drug, and rock and roll lifestyle. This is a gross mischaracterization of the conduct. The offense of conviction are serious federal crimes. Other defendant convicted of Mann Act offenses involving abuse and violence receive significant sentences. Sentences similar to what the government is recommending today. And that's because this is not just a case of transportation for prostitution. It's a case about transportation for prostitution and violence. The defendant admitted to the violence at trial, and to not account for it now would be the less would be would be to let the defendant get away with years of domestic violence and abuse. The second thing I want to focus on is to zoom out and speak about the people that were harmed by the defendant's offense. Cassie and Jane specifically, but multiple others were subject to the defendant's abuse and violence. And finally, I want to speak about the other 3553A factors, including deterrence and the history and characteristic of the defendant. Throughout these proceedings, I think it's clear that the defendant doesn't understand or appreciate the gravity of his criminal conduct. Even now, at sentencing, his conviction of 2 federal crimes for which he sought acceptance points, he doesn't fully grapple with how his action got him here. His respect to the law is just lip service. The defendant himself made this point clear. He's facing a maximum sentence of 20 years. The probation office recommended 60 months, and the government is asking over 11 years. And yet, as his supplement submission on Wednesday indicated, he has booked speaking engagement in Miami for next week. That is a height of hubris, Your Honor. Assuming this court is going to ignore the guidelines, ignore the law, ignore the recommendation of the probation office and the government, and just let him in Miami on Monday, that is the opposite of demonstrating respect for the law. Focusing on the nature and circumstances of the offense, and particularly the scope of the conduct, which is staggering. The defendant's criminal conduct was not incidental or casual or a monetary lapse in judgment. The defendant engaged in freak-offs, hotel nights from 2009 until 2024. That's 15 years. The freak-offs and the hotel night happen all the time, often on a weekly basis. The defendant was responsible for transporting many individuals across state lines to participate in the freak-offs and hotel nights. As the trial record made clear, sometimes several escorts were transported from the same event. That's a lot of freak-off and a lot of hotel nights. It's a lot of traveling for freak-offs and hotel nights. And the defendant knew that this was illegal. All right, y'all. I'm about to after I finish 38, I'm gonna stop. I'm gonna take my butt on and take me a break, and I'll finish this tomorrow. Yeah, I'm gonna finish this tomorrow. Okay. Let me just finish to 38 here, and then I'll continue tomorrow. If you guys don't mind, because I did say I wasn't gonna read all of it right now. Okay. And I'll start at 39 tomorrow. I just realized I gotta take care of some stuff. I can't be on here all night. Let's see. What was I at? Let me start out over here. That's a lot of freak off and a lot of hotel nights. It's a lot of travel for freak offs and hotel nights. And the defendant knew that it was illegal. His lawyer may have tried to argue that this wasn't prostitution, but just as this court knew it was, the defendant knew that it was too. He knew that he was engaging in illegal conduct over and over again, and he did it anyway. Our criminal justice system does not let people do this without consequences. So, Your Honor, the scope of the conduct is sufficient and is separate from the defendant from any other defendants who are sentenced for a Mann Act conviction, in which I'll talk about more in a moment. But the more remarkable thing about the manner in which the defendant committed the offense is the abuse, the violence, and the freak-offs and hotel nights took place in the context and long-term relationship. The defendant tried to paint these relationships as mutual, but the records speak for itself. And the court heard Cassie testify about having freak off as she was overdosing on drugs. So I'm gonna start tomorrow at you're welcome, Louise 03. All right. Just remind me, Louis, that I will start tomorrow morning at page 39. Louis, I'm gonna hold you responsible to remembering page 39, Louis. So you better come in here tomorrow. I'll set it up after I do my prayer in the morning. I'll do it early so I can get this done, okay? Okay? Louis, 03, remember, I'm going to blame you.
Yeah, we are planning to appeal. We are planning to appeal. We think we have strong bases to appeal. The strongest basis is that the jury reached a verdict on coercion. It found there was not coercion. And I think the judge said coercion today as a basis for a sentence at least a dozen times. We think that is unconstitutional. We think that a jury verdict should mean more than our jury's verdict seems to mean. And so we are planning to appeal.
Absolutely. Filed a cross appeal. What would happen in that regard if they filed a cross appeal and then Sean Diddy Combs get a higher sentence?
He would not get a higher sentence, and they're not gonna cross appeal. We're gonna appeal. We think we're right, and they'll respond to the appeal, and it'll be decided by the Second Circuit as soon as.
Tell us about the conversation you had with your client after the sentencing.
Consensual. The judge clearly thought the sexual encounters weren't consensual.
Because he's biased.
Make of his remarks.
He's biased.
I'm happy to go. So we think that's just absolutely inconsistent with the jury's verdict. I mean, the jury's verdict was resoundingly clear. There was no sex trafficking. There was no racketeering. Everything was consensual. Everything was adult, which is why he was convicted only of the prostitution offense. What we feel happened today was that the judge acted as a 13th juror,
Yes,
one that we
did.
did not choose, and that he second-guessed the jury's verdict.
Okay, that's it. That was Mr. Steele and Agafino and all of them were standing outside. And that was a question that they asked him. In the meantime, y'all, I will see you guys tomorrow. Louis, you're responsible for me getting in the right track tomorrow. All right, y'all. Good night, everybody. You're welcome, CJ. All right, Serena, I got you. You'll be on at 10:30. Okay. But I think I'm going to do it like around 8 o'clock, 9 o'clock, something like that. All right? That's Kobe making noise, y'all. Good night, everybody. I'll see y'all tomorrow. Remember, page 39. Okay? Later. Love you guys. Have a good night. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this online space. It's just you and me. We laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click